Good afternoon, and welcome to Certifying Confidential Financial Disclosure Reports. This is part 2 of our massive open online course. My name is Patrick Shepard, and I'll be your instructor today. Thank you for joining us for part 2 of this course. We hope you found part 1 to be very, very helpful. Cheryl shared with you a lot of useful information and resources that we hope will benefit you in your certification of confidential financial disclosure reports. Today we'd like to take some time to help you find out how you retain that information and if you're able to use that information in an applied sense by going through an exercise. But before we do that, what we'd like to do is take some time for your questions. I know Cheryl ran almost the full 90 minutes on Monday, and there wasn't a great deal of time for questions. Today we hope not to run quite that long with the prepared content, so we do have some time for questions. So those of you who are on the Hangout, please feel free to use the question and answer app in the bottom right hand corner of your screen. We'll also open up the phone line, and we've received some questions via email and comment between Monday and today, so we'll also be addressing those. Kevin would like to go ahead and open it for any questions we might have.
Thank you. If you would like to ask a question, please press star, then 1. Record your first and last name clearly to ask your question. To withdraw your question, please press star, then 2. Once again, to ask a question, please press star, then 1. Record your first and last name clearly. One moment.
And we would like to remind everyone before you ask a question that there are hundreds of officials on the call and the Hangout today, and also that these are confidential financial disclosure reports. So if you have any questions about the specifics of a live report, please direct those to your desk officer. We'd be happy to help you with them, but we don't want to inadvertently share any sensitive information on the Hangout.
We have no questions on the phone line.
Okay, and I'm not showing any on the Hangout. If the folks on the Hangout do have questions, please feel free to type them in. We did get a couple of questions between the session on Monday and today, and I'd like to address those. The first question that we received had to do with defined contribution plans. And the question was, if you see a filer has reported, say, a 401k on Part 1 of the form, but has failed to report the agreement or arrangement on Part 4, and you already have all of the underlying assets on Part 1, is it okay to make that annotation on Part 4 for completeness sake? And the answer generally is yes. If it was a new entrant report, I'd want to consult with the filer to make sure they understood the omission, and then with their concurrence, we could make that amendment. One piece of information that we do want to make sure we collect in those cases is to know whether or not the former employer is going to continue to make any contributions. But if you know from previous reports that that's not a concern, that the employer is no longer making contributions, and you can see on the previous report it was correctly reported, you can go ahead and make that annotation, notify the filer, and ask them to correct you if your assumption was wrong. Again, these are confidential financial disclosure reports, and the goal of the report is to prevent conflicts of interest. The goal, unlike public financial disclosure, there is no role of disclosure for its own sake, because there is not a public scrutiny of these reports. So we really want to focus on the prevention of conflicts, and we can use some common sense when making annotations. We just want to make sure that the filer understands we made the annotation for a number of reasons. The first being so they don't make the mistake next year, and also if we are wrong in our assumption, they have an opportunity to correct us. So thank you very much for that question. The second question we had is, what do we do about late filers, people who miss the deadline on the filing of the confidential financial disclosure report? And the answer is, unlike the public system where we have defined monetary penalties, the methods that we have to encourage people to file or to discipline late filers are administrative in nature. So you want to work with whoever in your agency is responsible for administratively sanctioning misconduct, and work with them to help get any filers. But we want to make sure that our filers know about the requirement. We want to give them every opportunity to file appropriately. But if you run into a situation where someone just refuses to file or is habitually late, you can explore administrative sanctions. It looks like we have another question coming in through the Hangout. Let me have a look here. Just a second, please. So Lori C. asks, So she suggests that in her practice of reviewing confidential financial disclosure reports, filers sometimes push back against the request for the underlying holdings of the 401k and asks if we have any practical advice as to where filers might find that information. And I do realize that a lot of folks have kind of set it and forget it retirement plans. They made some elections on their first day on the job at a previous job. They've left them alone for many years. And and they don't think about it frequently. So the question is, where do they find them? A good place to start is to call the sponsor of the 401k. Those people should be able to provide that information. If they have a website, they may be able to log in and see the contents of the 401k. It's much like our TSPs that you're probably all familiar with. You make your elections and then you don't think about it. But you can go to their website and find out what is within the report. Another thing you can do with the 401ks is to look for any statements. We try to synchronize the filing season with the tax year, so oftentimes around that time we'll be closing out the books. The administrator of the plan will be sending annual updates. So you just want to keep your filers attuned to the fact that they'll probably receive a statement around filing time and to look for that. And if not, they should call the firm sponsoring the 401k. So I hope that answers your question, Lori. And do we have any other questions on the Hangout or on the phone?
There are no questions on the phone line.
Excellent. Well, thank you all for those very good questions. And I think we'll go ahead and get into the debrief of the exercise. I hope that everyone has had an opportunity to look through the materials and at least take an initial crack at the exercise. I understand lots of folks are busy, so you might not have had a chance to do that, and that's okay. You'll still be able to get a lot of value out of this exercise. But we do like to give you an opportunity to give it a try on your own. And the reason we want to do that is so that you can find out what you've retained, what you had trouble with, where you are going to run into problems. And if you did have the opportunity to look at the materials and go through this exercise, you may have found that this is kind of the cartoon version of an OGE Form 450. This isn't a particularly complex report. We give you a lot of information, but that's okay. We want to start small and give you an opportunity to get comfortable with the form before we get into a more complex report, which is what we're going to do tomorrow. So before we get into the report, if you have taken a look at it and you've printed out the materials, I'd encourage you to get out those printed materials. I will be sharing the slides on the screen, but the text is a little bit small, so you may have an easier time following along on your own materials. It also gives you an opportunity to take notes. Another note on notes, we will be distributing an updated slide deck that has annotations about the questions you should ask about the entries for each of the two exercises after the massive open online course is completed. So if you miss a note, or you don't have time to write something down, or you miss something that I said, that's okay. We're going to be sending you sort of an answer key, so you'll have that information. All right, let's get started and take a look at some of the materials. So the first thing that we need to know is for which agency we're reviewing confidential financial disclosure reports. Cheryl mentioned on Monday the nexus between the responsibilities of the employee and their financial holdings. The confidential financial disclosure report gives us the holdings. To know about their work, we have to know about the mission of the agency and the role that the employee plays in the agency. So we've provided you a profile of our fictional agency for the purposes of this exercise. And you can see here the agency we're working for is the Food and Beverage Administration, a fake agency, but maybe not unfamiliar to some of you in its mission. And its mission is to evaluate and approve all foodstuffs and beverages headed for the marketplace. So these are our food inspectors. They do approval of foodstuffs and beverages headed for the marketplace. And they have some special requirements. And if you don't know if your agency has these two things, I'd really encourage you to find out whether you have any statutory restrictions or supplemental regulations. Many agencies, upon their formation in their organic statutes, were given specific ethics considerations and restrictions. If you're an agency that oversees the financial services industry, it's very likely you might have a statutory restriction. If you're a regulatory agency of any kind, you may have a statutory restriction. And if you don't know whether or not this section applies to you, ask someone who is more experienced in your agency, your Office of General Counsel, and find out if there are any supplemental restrictions for your agency. In the case of the Food and Beverage Administration, employees are prohibited by law from holding financial interests in foodstuffs and production. And that kind of makes sense. It's sort of a broad brush way of thinking about conflicts of interest. And this restriction is in addition to all of the other ethics laws and regulations that we discussed on Monday. They also have a supplemental regulation. So supplemental regulations can be issued by agencies jointly with the Office of Government Ethics. It requires our concurrence and sign-off. But to the extent that an agency finds the employee standards of conduct and government-wide restrictions to be insufficient to manage the potential for conflicts of interest at their agencies, they can impose supplemental regulations, and these must be enacted through a regulation concurred with by OGE. And in the case of the Food and Beverage Administration, all employees are prohibited from holding any interest in major foodstuff producers, as well as interested parties such as vendors, marketers, and related research and development facilities. Additionally, they must obtain prior approval for outside employment and outside activities. These supplemental regulations for our fictitious agency are not unusual. Many agencies have a prior approval requirement for outside activities, and many also have restrictions on what kinds of financial assets employees can hold. So we want to keep those in mind as we go through this presentation. And if you don't know if your agency has supplemental regulations, it's important you find out before you start reviewing confidential reports. We have another question, it looks like. This is a great question. Cherry Tolliver asks, how long does a typical 450 review take? 30 minutes, an hour? That's an excellent question, Cherry. And if there was such a thing as a typical 450, I'd be very happy to answer that question. But the fact of the matter, in my experience, and I've worked in an agency and reviewed hundreds of 450s, I've reviewed many executive branch agencies and looked at probably thousands of 450s in the course of those reviews. And I found an enormous range in the amount of time it takes to review a 450. Some agencies and offices, you'll find strings of reports that there's nothing to report or very little to report, and they may only take you 5 or 6 minutes to review. In other professions, you might find that a typical report could take you half a day or more. I think those are more the rarity when it comes to confidential financial disclosure. But in my experience, you'll find that 90% of your reports take about 50% of your total review time, and that final 10% takes the other 50%. So there's a great deal of variance between the complexity of the reports and how long they take to review. But that's an excellent question, and I understand that people are curious because they want to benchmark and manage human resources in their agency to help with the review. But I can simply assure you from experience that there is an enormous variance in the time between a relatively simple report, which could take just a few minutes, and a complex report that could take a week or more, if you have a very complex financial life of an employee. And that actually brings up a really good point, and I thank you for that question. When it comes to financial disclosure review, sometimes when you run into that complex report, it's important to get help. Here at OGE, we review a lot of public financial disclosure reports, and the majority of those reviews a single reviewer can take care of. It's not tremendously challenging. But a minority of those reviews are very complex, and even though people here have been reviewing these reports for many years, it's often important to get together with colleagues and get more than one set of eyes looking at a complex report. So where you run into those really complex forms, maybe you have an employee who's very wealthy and they have a complex financial life, or you have an employee who has broad-reaching responsibilities and it's difficult to figure out the conflicts issues, it's okay to ask for help and to seek out the advice of colleagues at headquarters or someone who's more experienced, or even just someone who sits nearby. Because those complex issues, it often helps to have more than one person watching. So thank you for your question. Also here in the agency profile, we have a prohibited sources list. And you'll know if you've taken some of our other classes that the concept of prohibited source comes from the gifts regulation. It's someone who does or seeks to do business with the agency, someone our agency regulates, someone who is affected by the performance or non-performance of an employee's duties. And you might be asking yourself, why do we have a list of people who are prohibited sources for purposes of gifts thrown in here with the financial disclosure review? And the reason is that list, you might call it a contractor list if you work at a contracting agency, or a regulated entities list if you work for a regulatory agency. It gives us a hint as to what kinds of entities are likely to pose potential conflicts of interest. So if you have a list, your contracting office might provide it, your headquarters ethics office might provide it. It gives you it's a very powerful tool to find out, what kinds of entities and who might pose potential conflicts. I would caution you that it's not the sole universe of entities that might pose conflicts. It is merely a guideline, but an extraordinarily powerful one. So if you don't have one, or if you've not been given one prior to conducting your review, you might try and seek one out. And if your agency hasn't put one together, you might work with your contracting folks to see if you can. So I think it'll be helpful to you as we go through this exercise to keep the agency profile out and on your desk so you can refer back to it. For those folks on the phone, we will be having another Q&A at the end, so I will be opening it up when we're finished with the exercise. So if you have any questions, please feel free to jot those down. I'd be happy to address them with any time we have remaining. Those folks who are on the Hangout, please feel free to ask your questions throughout. I'd be happy to respond to them as they come up or as we have time. And again, thank you guys for your questions. So the other part of the one piece of information that we need, in addition to the confidential financial disclosure report itself, is to know what our employees do. As Cheryl mentioned, we are looking for that nexus between the employee's responsibilities and their financial interests. And the 450 provides us with their financial interests. But in order to find out what the employee does, we're going to need to do a little bit of digging. Many agencies keep a position description in the financial disclosure file. If you do that, that's a great practice. It gives you a window into the duties and responsibilities of the employee. Some other agencies enlist managers or supervisors as intermediate reviewers. They are in a fantastic position to help you identify matters to which an employee might be assigned or has been assigned. So that's another way that you can find out and incorporate knowledge about an employee's particular duties into the review process. Another way you can do that is to contact the employee directly. The outcome of the confidential financial disclosure review process should be a piece of advice to the employee, either a piece of advice that says, we've reviewed a report and considered your duties, and based on our review, we don't think you have any potential conflicts of interest that you need to be concerned about. Or alternatively, that we've reviewed your report and your duties or proposed duties, and we think the following conflicts are things that you need to be concerned about, and we recommend the following remedial actions. So if you think about confidential financial disclosure review as a kind of advice and counsel, collaborating with the employee to get more facts is very normal for us in an advice and counsel role, and it's equally as common in the confidential financial disclosure review process. So here at the Food and Beverage Administration, our employee is Pete Moss. Some people think that's funny. I think that's kind of funny. His position is he's a GS-15 branch chief. He was hired way back in August 1999, and so we can kind of guess he's a career federal employee. And his duties are to oversee the FBA research facility for beverage control. The facility tests artificial preservatives introduced into foodstuffs. In this case, all beverages FBA approves for consumption. And his qualifications are that he's a chemist. So he's sort of a chief chemist in our beverage control section. So we want to keep that in mind also as we go through the confidential financial disclosure report. And we've also provided you with FBA's prohibited sources list. So someone either in the regulatory affairs office or the contracting office has put this together for us. And again, this is a very good guideline, but it is not the beginning and end of the financial disclosure review process. So it's possible we could have ethics concerns outside of things on this list, but this provides us a very good starting point. And certainly if we see anything reported on the form that's on this list, we want to make a note and make sure that we talk to Pete about our concerns and what actions he might need to take to avoid any conflicts of interest or other ethics concerns. As Cheryl, I'm sure, mentioned on Monday, when we're looking at these reports, when we certify them, we are certifying that the employee is in compliance with applicable laws and regulations, and that's all applicable ethics laws and regulations. So we've provided you some summaries of the statutes and regs If you have those available, I'd encourage you to keep them out. It's also helpful, I find, when I'm doing these reviews, to keep a copy of the Code of Federal Regulations with the ethics provisions and the assembled ethics laws so that I can refer to them as I go through the report. All right, well, let's take a second and get into the actual review of the report. So here is the cover page of the report, and the cover page is a great place to start your review. First of all, it's the first page that you'll encounter when you look at the report, but it also contains some very important information that we want to make sure is present before we begin our review. You'll note here that the agency is not stamped date received by agency yet. It's very important that you date stamp these when you receive them. This begins the clock on the 60-day review period. It's important for audit purposes, and it also indicates that the report has indeed been received and seen by someone in the ethics office. If you have an electronic filing system, this is a problem that is sort of automated away, but if you're still using paper reports, make sure you date stamp them. We have some information about Pete. We have his position title, email address, very important if we have any follow-up questions, a way to reach him on his work telephone. We see that he's an annual reporter here. He's not a special government employee. We have his business unit address. So I want to make sure that we have at least enough information that we can get in touch with Pete when we have any questions, or to provide him with any ethics advice that is required by our review of the report. So you want to look quickly and make sure that you have that. The next thing I'd encourage you to do is look at these sections here in the middle, the check boxes. This is going to give you a good hint at how complex your review is going to be. In some years, and with some filers, you might find that they've checked no for all these boxes, that they have nothing to report. If that happened to me with a new entrant filer, I'd want to talk to the new entrant filer just very briefly to make sure that they understood the reporting requirements and indeed they don't have anything to report. I'd encourage you to be a little bit diplomatic in that regard. If someone has nothing to report, you can say, I see that you've nothing to report. I suspect that's probably because you're a career federal employee and you have TSP and the normal stuff, and they say, yeah, that's all I have. So I've ticked no. So I just wanted to make sure that you understand that if you have any stocks, bonds, mutual funds, etc., they should be reported, and just give them a brief understanding of when they would need to disclose things and make sure that they didn't inadvertently check all those no boxes. But with an annual report, if this is something you've seen several times before, the filer has checked no, that's okay. You can just go ahead and certify the report. So back to Cherry's question, that report wouldn't take very long to review. A report like this, where we have something reported for each part, is going to take us a little bit longer. For every item on this list where an employee has checked yes, I like to take a quick look at the rest of the report to make sure that there are corresponding entries. So if a filer hands you this and they've checked the yes box for all 5, and I look at the last page and there's nothing reported on part 5, or there's nothing reported on part 1, I know I'm going to have a follow-up question, and if I can catch that before the employee's left my office, all the better. So that's a place that I start my review. I make sure that the cover page corresponds to what's actually disclosed. Finally, you'll see here that Pete has yet to sign his report. It's very important that your filer sign and date the report. That is when they certify that the statements they've made are true, complete, and correct to the best of their knowledge. And without it, unless it's a draft that you're helping someone with, you should probably just hand it back to them and say, please sign this, and I'll begin my review. We also see down here that there's a block for reviewers' use only. And as Cheryl mentioned on Monday, there are 2 places that you can sign. Some agencies use intermediate or supervisory review, so there is a location for their signature and contact information. And that's very important. So if you're relying upon supervisors or other intermediate reviewers to help you with the conflicts analysis, you need to be able to contact that person in case you have any questions. So that's why we ask for their email address and phone number. And then finally, we have the signature and title of agency final reviewing official, and any comments that you might have. If you have extra comments, you can tick the box and attach them. So aside from the signature and the lack of date received by agency, this report is looking pretty good so far. Next, we get into part 1, assets and income. And this is where you're going to have the majority of your questions for filers. This is where a lot of the interesting stuff comes up. It's also where filers tend to make the most mistakes, especially if they're novice filers. And a good hint, actually, as we go through this, if you're using a paper-based system and you make annotations, you have a back and forth with the filer where you're getting more information, you're filling out and completing the report with their concurrence. It's a good idea the next filing season to provide them with the updated report so that they're starting with a good report when they start to fill out their next year's report. So if you're not doing that and you're using a paper-based system, it's a good idea. It can save you a lot of time. It's initially time-consuming to send out their report with the request to file, but especially if you've made a lot of changes, giving them the updated and corrected report is very helpful. So let's look at this first item, yo-yo pension, yo-yo brands pension. And pensions give folks a lot of trouble, and this is an area where we have a lot of questions for filers. What is the first thing, just take a minute to think to yourself, what is the first thing that strikes you about the yo-yo brands pension? Well, the first thing that I saw is that yo-yo brands appears on our prohibited sources list, which means it's an organization that does business with our agency or is regulated by our agency. In the case of the FBI, I would guess that they're a regulated entity. And that doesn't pose immediate sirens going off concerns, but it does pose some concern. And we recognize the possibility here of a nexus between Pete Moss's financial interest and his duties. And if you remember, Pete Moss is in charge of our beverage office at the FBA. So some questions I would have, and we have some clues later on in the report about this pension, is what kind of pension is it? Because we have a number of varieties of pension. We've talked a little bit about 401ks already. And the simple entry yo-yo brands pension doesn't really tell us if this is a defined benefit or a defined contribution plan. When we look at Part 4, we're going to find something that suggests that it's a defined benefit plan. But let's take a minute to talk about the differences in our analysis depending on what kind of pension this is. In the event that this is a defined contribution plan, that is a plan where an employer makes contributions to an account which are then invested by the employee in various holdings. This would be something like a 401k or a 403b. The thrift savings plan is also a defined contribution plan. In the case of a defined contribution plan, our conflicts analysis goes to the underlying holdings of that plan. So if this was a yo-yo brands 401k, our first question would be, Pete, what do you hold in your yo-yo brands 401k plan? And once we receive that information, our conflicts analysis would go to those underlying holdings. Unless for some reason yo-yo is continuing to make contributions to his 401k, we wouldn't be especially concerned with them as an entity that poses potential for conflict. So the important thing to remember with defined contribution plans is that we're looking for the underlying holdings and then our analysis focuses on those holdings. In this case, we have information to suggest that this is what's called a defined benefit plan. And a defined benefit plan is really a plan where an employee and an employer have an agreement that upon reaching some threshold, like retirement age or years in service, the employer agrees to provide the employee a fixed benefit. So this is more of a contract between the former employer and the employee for a future cash benefit typically. And in this case, our conflicts of interest analysis goes to the sponsor of the plan, but it is not a full 208 analysis. We do not impute the interests of an organization with whom someone has a pension to that person. We have what we call here at OGE a 208 ability or willingness situation. And what this means is we're looking at the employee's individual financial interests. The interests of yo-yo brands are not imputed to the employee because of this relationship. But the employee does have an interest in the financial health of yo-yo brands because they are an organization that owe him a future benefit. So what we say is our employee should not participate personally and substantially in any particular matter that would have a direct and predictable effect on the ability and willingness of yo-yo brands to make good on their pension obligation. I'll say that again. The employee should not participate in any particular matter that would have a direct and predictable effect on the ability and willingness of yo-yo brands to make good on their pension obligation. So if Pete were to take action that could, say, bankrupt Yo-Yo Brands or significantly harm their financial solvency, that could affect their ability and willingness to pay him his pension in the future, and he would therefore be prohibited from participating in that particular matter. So in this case, the pension is indeed a defined benefit plan, and we want to make sure that we have recusals in place so that Pete doesn't inadvertently participate in particular matters that could affect the ability and willingness of Yo-Yo to make good on his pension obligation. So I hope that is helpful to you, those two possible analyses for retirement plans. So again, defined contribution plan, get the underlying holdings, do an analysis on the holdings. Traditional pensions, we have that ability or willingness recusal that's required. And again, that is a case where you have an agreement to provide some future benefit to the employee. And we can see on part 4, I believe, that Pete has described the nature of that arrangement. And in fact, he's entitled to $1,500 per month. So let's take a look at this second entry. This is probably an entry that many of you have seen before on reports, and the sight of it probably frustrates you. It says Fidelity Mutual Funds. So think to yourself, what is it immediately when you see this entry that comes to mind, and what information is it that you're going to require? Well, the first thing that comes to my mind is I need to know which Fidelity Mutual Funds the employee holds. And the reason for that is that there are hundreds of mutual funds available from Fidelity that are in the Fidelity Fund family. And some of them are going to be of significant concern to us, and others are going to be no problem at all. We note here that under our important definitions, we have a definition of diversified mutual fund. And we provide that because they don't need to be reported. And the reason they don't need to be reported is because they are exempt from coverage under 18 U.S.C. Section 208, and they cannot pose a conflict of interest. So because the purpose of our exercise is to identify potential conflicts, we don't need to have the names of the diversified mutual funds because they're exempt from coverage. That isn't to say that if you have a filer who has disclosed diversified mutual funds that you necessarily have to go back to them and with their permission take them off. You can simply ignore them. The reason we made this change to the form back in, I think, 2007 was to prevent ethics officials from spending an inordinate amount of time going back to filers to get the specific ticker symbols or full name of obviously diversified mutual funds. But in this case, we don't have any indication that these are diversified mutual funds. We don't know what funds they are at all. So we're going to have to ask Pete what those funds are. We're going to have to find out which Fidelity mutual funds he has. And if he has some sector funds, particularly sector funds in the food and beverage industry, we might have a problem. So our conflicts of interest analysis will go to those individual funds. And if we find that there is a nexus between Pete's duties and the sector the fund invests in, we may need Pete to recuse, rely on a regulatory exemption, or divest himself of those funds. So that's something you want to keep in mind. Make sure that you get the names of the actual funds. How about this next entry? How do folks feel about this? What is the first thing that comes to mind when you look at entry 3? We have an indication here right after the 3. Parenthetically, we have an S, which typically indicates that this entry applies to the filer's spouse. And then we have a note that it's an employer, and that the employer is Kraft Foods. So I'm not sure. So think about what would immediately come to mind if you were to happen upon this entry. What are the first things you're going to check and want to be careful of? So Lori C asks, how should Pete have stated this on the form? I think, Lori, if you're referencing entry 3, the entry is correctly disclosed. The first thing that I'd look at here is that indeed Kraft Foods is correctly disclosed as the spouse's employer. It's going to pose some substantive concerns for us in addition to the disclosure requirement. If you're asking about the mutual funds, we should have separate entries for each of the mutual funds with their complete name. And if the employee includes the ticker symbol, all the better. It's not a requirement, but we'll need the full fund name. But in the case of Kraft Foods, this is a good entry. It's properly disclosed. The first thing that comes to my mind is I think Kraft Foods is in the food production and beverage production business. So we definitely have a nexus between Pete's role here at FBA, as well as FBA and its mission, and his spouse's employer. So that's a good question. Thanks, Lori. So you're referencing entry 2. Yeah, entry 2 we should have the full names of the mutual funds. One mutual fund per line would be best, but if they put a few on the line, that's okay, as long as we can identify the specific funds. And we'll show you how that looks on the updated slide deck. In the case of the spouse's employer, we obviously have a nexus between Kraft Foods and the business we do at the FBA. So that's going to pose a concern for us. And the degree to which we need to be concerned and the scope of that concern is going to be contingent upon a question we're going to need to ask Pete. And that question is, does your spouse have any stock or other benefits related to her employment with Kraft? Very often you'll find that filers forget to report their spouse's employment-related assets. And the reason they do that is the same reason they forget to report the underlying holdings of their 401ks. They don't think about it every day. It's not something that's immediately comes to mind. But anytime you have a spouse who is working for a corporation, you want to inquire and make sure that they haven't inadvertently failed to report, say in this case, Kraft stock or Kraft options, Kraft restricted stock units, or any other benefits that might arise from that employment relationship. The reason this is important is because it affects the analysis that we're going to conduct with respect to conflicts of interest. Let's take this entry just as it's disclosed, and imagine that his spouse is employed by Kraft Foods. She's purely a salaried employee. Her compensation is in no way tied to the overall performance of Kraft. She's just regular salary, goes to work, gets a paycheck. She doesn't have any equity interest in Kraft, so let's say she does not have any stocks or stock options or restricted units, no performance bonus, just straight salary. In that case, if you look at 18 U.S.C. Section 208, you'll see that in those lists, in that list of persons whose interests are imputed to the employee, we do see an employee's employer, but we don't see the spouse's employer. The spouse is included in that list, but not the spouse's employer. And this is very important when we're doing our conflicts of interest analysis, because we look to the interests of the spouse. This is very much like the defined benefit pension plan. So if we have a situation where the spouse's employer, where the spouse is merely salaried, there is no equity interest, our analysis under Section 208 goes to the spouse's financial interest. And the spouse has a financial interest in his or her continued employment with Kraft and his or her level of compensation. So what we would say to Pete in that case is, Pete, you may not participate personally and substantially in any particular matter that would have a direct and predictable effect on the ability or willingness of Kraft Foods to continue to employ your spouse or continue to employ your spouse at her current level of compensation or his current level of compensation. So that's very important. So if it's just straight salary for the spouse, there's no equity interest, no bonus, the compensation isn't tied in any way to the performance of the company, we would have a 208 ability or willingness, and then we would look at the impartiality concerns. If you look at 5 CFR 2635-502, you'll see that in that list of covered relationships, spouse's employer is listed. So we would want to be careful that for appearance reasons, we advise Pete to recuse from any particular matters involving specific parties that involve his spouse's employer, because he does have a covered relationship with Kraft Foods. But that situation is an easier conflict of interest and appearance concern to manage, so we'd implement the 208 recusal for the ability or willingness of Kraft Foods to continue to employ his spouse at his or her current level of compensation, and also the 502 recusal for any specific party matters involving Kraft. Let's say the spouse, let's say that Pete forgot to disclose his spouse's bonus tied to the performance of Kraft, or forgot to disclose stock in craft or restricted units or stock options in craft that his spouse has as a result of her employment. In that case, all of the interests of Kraft Foods would be imputed to Pete. His spouse would have an equity interest in the company, so it would be as if she's standing in the shoes of the company for purposes of our analysis. And again, 208 imputes all of the spouse's interest to Pete, so Pete could not then take any action that would have a direct and predictable effect on the financial interest of Kraft whatsoever. So there's no ability or willingness caveat in that case at all. So that's why it's very important for us to find out if there's anything else, any equity interest the spouse has with respect to her employer or his employer. So you can see as we go through these that little nuances make a big difference to our analysis, and it's important to be careful that you have all of the information that you need before you begin conducting your legal analysis. All right, let's take a minute and look at lunar cheese. And what do we know about lunar cheese? Is there anything when you see this disclosed that immediately springs to mind? The first thing I did was to look at our prohibited sources list. And I found that lunar cheese does not appear on the prohibited sources list. But that doesn't mean that we don't have any problems. Lunar cheese seems to be a food company. That means they're probably a regulated entity, even if we haven't specifically identified them on the prohibited sources list. We want to know whether or not they're in the beverage industry, because remember, Pete is involved in the beverage industry. And we'd also want to remember that we have that statutory restriction and the supplemental regulation that prohibit our employees from holding stock in food producers. So even though lunar cheese doesn't find its way onto our prohibited sources list, this may actually be a prohibited holding. So we'd want to make sure to do that analysis and, if necessary, make Pete aware that he needs to sell lunar cheese. Cheryl probably mentioned this on Monday, but if you have a supplemental regulation, a restriction like this, the exemptions for Section 208 don't apply to that restriction. Those exemptions that we find in 2640 apply only to conflicts of interest under 18 U.S.C. Section 208. If you have a supplemental agency regulation or a statutory restriction, you have to look for any exceptions that might be built in there. The 18 U.S.C. Section 208 ones do not apply. So this might be a very small holding in lunar cheese, and Pete would likely have to divest himself of it anyway. So that's a relatively straightforward one. It's just something that we're going to need to make sure we advise Pete that, this being a food company, he's subject to those additional restrictions and should divest himself of the stock. How about this next entry, Great Green? Well, in this case, things have gotten a little bit easier for us. They do appear on the prohibited sources list. We don't know why they're on the prohibited sources list. We don't know if it's because they are a food producer or they could be an agency contractor. But, we're going to have some concern. So we want to look at our Section 208 analysis and determine whether or not Pete's duties are likely to have a direct and predictable effect on Great Green. We'd also want to find out if Great Green is a food producer, whether or not they're covered by our statutory restriction or a supplemental regulation. And if they are, again, we're going to need to ask Pete to divest himself of Great Green if it is in fact a prohibited holding. And finally, on part one, we have Pete's thrift savings plan. And those of you who have been doing this for a little while may know that the TSP doesn't need to be reported. And the reason for that is the TSP holds diversified mutual funds and cash equivalents that don't pose conflicts of interest, so it doesn't need to be reported. If this was the only error on the report and the only issue I had to discuss with Pete, I would not go back to Pete to make sure to take off the TSP. I might make a note next time I'm sending out the request to file. Remember, you don't have to disclose your TSP. In this case, we're going to have a lot of questions for Pete. We're going to have a lot of questions and guidance, so I just mentioned in that guidance that, remember, next year, don't worry about reporting your TSP. It doesn't need to appear here. So that's taken us through part one. I'm not showing any questions on the Hangout. Kevin, would it be okay to open up for questions on the phone briefly?
Yes. Once again, if you would like to ask a question, please press star, then 1. Record your first and last name clearly.
Excellent. Thanks very much.
You're welcome.
Okay, and we'll have a couple of other opportunities for questions as we go through. And again, the folks who are on the Hangout, if you have questions, please feel free to type them. I'll be happy to address them as they come in. Okay, let's turn our attention to Part 2, Liabilities. And as Cheryl mentioned on Monday, the reason we have people disclose liabilities is primarily to find out if we have prohibited gifts that are taking the form of a liability. So the questions that we have are going to be related to our gifts analysis, and that's going to be, are these loans from prohibited sources, and are they on terms that are generally available to the public, or are they on favorable terms? And if we have loans from prohibited sources and the terms are favorable, we're going to have some concerns. We're going to want to do a gifts analysis and work through that and make sure we don't have a prohibited gift. So our first one here is Yo-Yo Brands, and it is a personal loan. And Yo-Yo Brands is on our prohibited sources list, so we do have a question here, and we are going to have to work through a gifts analysis. Think to yourself, what are some of the questions I'd want to ask Pete about this entry? Jerry has an excellent question. She says, would Pete need to sell his assets in Great Green before we are able to certify the 450? And that's a great question. And the way we typically deal with these is that Pete wouldn't necessarily have to execute the transaction itself before we certified the 450. But what we would want to do is get an agreement from Pete in writing that he is going to sell the asset. And we want to specify a time frame in which he is going to sell the asset. So we'd implement a recusal. We'd say, Pete, you cannot work on anything affecting the financial interest of Great Green until you've sold the asset, and you must sell the asset within a specified time period. The standard time period specified in our regulations is 90 days. If for some reason your agency needs Pete to be able to participate sooner than that, or you'd like him to disclose sooner, you can work with Pete to find a time frame that works for your agency. But once you have the agreement, one, not to participate in any government matters, any particular matters that would affect Great Green's financial interest, and you have the agreement to sell, and that's in writing, you can certify the report, and you want to note that in the comments block. You'd also want to follow up with Pete and make sure that he has executed that transaction within the time period before you allow him to participate in any particular matters that would affect the interests of Great Green. But that's a great question. Thank you. So looking at the liabilities here, we have Yo-Yo Brands, and we have a personal loan. And again, Yo-Yo Brands appears on our prohibited sources list, so we may have a gifts concern. You might remember from Part 1 that Yo-Yo Brands is also one of Pete's, looks like it was Pete's previous employer. So we're going to want to know, what are the terms of this loan, and if we determine it qualifies as a gift, we're going to want to see if one of the exceptions applies. Hopefully Pete's been working here for many, many years, and we've seen this before and already conducted the analysis, so we don't have to worry about it. But we want to make sure that we'd either done that or that we will do it. So our question here is, what are the terms, what are the circumstances that led to this liability? And then the question would be whether or not it constitutes a prohibited gift. Now, this is very uncommon. You could probably spend a career looking at 450 reports and never have an issue come up with a liability that's disclosed on the report. But we put this here for sort of completeness sake, so you're prepared for it in the rare event that it occurs. We also have another personal loan from Angus Green. And we'd have similar questions here. We want to know, who is Angus Green? Is Angus Green related to Great Green, the prohibited source? Does Angus Green do business with our agency? Or is Angus Green a family member? We just need to know what the relationship is between our agency, Pete, and Angus Green, as well as the terms of the loan to determine whether or not we have a gift here that may be prohibited. And if we do, we want to make sure to do the analysis. Again, these aren't typical issues that you see on most 450s. You could probably review hundreds and hundreds and never have a problematic liability. But we wanted to show you what that looks like and the sorts of questions you'd want to ask. And if you're curious about the gifts analysis for these kinds of entries, we do have a number of gifts courses available on the OGE Institute for Ethics in Government YouTube channel, and I'd encourage you to take a look at those if you're interested. And we'll probably offer some more in the future. So moving on to outside positions. We do have a couple of outside positions reported here, and there's some things we want to keep in mind. One of our supplemental requirements was that there's prior approval for outside activities and employment. And that can be very good for us, or it can be problematic for us. The first thing that I would do when I see these positions reported is find out if we did a prior approval. If we have a form where we've already analyzed these, and we've given Peter permission to engage in these outside activities, and we've already done the analysis and given him advice, we don't have to worry about these so much. We just want to make sure we've taken care of it, maybe review the advice, maybe in our conversation with Peter that we're going to have after this, remind him of that advice, maybe provide him a new, fresh copy of it. But we might be good to go there. If we've not done that, we're going to want to take a look at these. And here we have a concern. So Pete is serving as a consultant for Lunar Cheese. Lunar Cheese does not look like they appear on our prohibited sources list, but it does seem that they're very probably a food manufacturer. So the first thing we're going to want to do is take a look at this for purposes of 18 U.S.C. Section 208. And he's serving as a consultant, so we'd want to find out the nature of that relationship, whether it's a contractual relationship and he's acting as a contractor consultant, in which case we would be concerned under 208 that Pete not participate in any particular government matters that would affect the ability or willingness of Lunar Cheese to continue to employ him or pay him his consulting fees. If it turns out he's actually an employee of Lunar Cheese, all of Lunar's financial interest would be imputed to him, and then Pete couldn't take any action that would have any effect on the financial interests of Lunar Cheese. In the event that it's merely a contractual relationship, we would look at the impartiality concerns, because he would also have a covered relationship with Lunar Cheese as well as an interest in his compensation. So we wouldn't want him to participate in any government matters that would involve Lunar Cheese unless authorized to do so. So we'd have a lot of concerns here. We have a massive open online course about analyzing outside activities, and I'd encourage you to take a look if you're new to that area, because it's an area where you can really run into issues with every one of the 20 plus laws and regulations we deal with in the ethics world. We don't have time to go through that entire analysis today, but we want to conduct it, and we have some major concerns when we see this on the report, and we want to make sure that we've taken a look at this before, or that we take a close look at it now. Some other big issues that jump out about this: want to make sure that Pete's not communicating with the government on behalf of Lunar Cheese. That could constitute a problem under 18 U.S.C. Section 205, our representational bar. We'd want to be careful to counsel Pete about misuse of position issues, so misuse of non-public information, misuse of his title, misuse of the authority of his position for private gain, all of those issues. So we're going to have a lot of advice around this if we've not already dealt with this position. In the case of the Knights of Columbus Annandale Council, things are going to get a little bit easier. One, this doesn't have to be reported. It's a fraternal or social organization. And, the reason we don't have these reported is because, we're doing a balancing act between the employee's privacy and our need to help them avoid conflicts of interest. So with Pete's permission, you could go ahead and remove this from the report. And these are an area where I do encourage you to redact this information from the report. People's political, religious, or social entanglements or affiliations are things that, maybe they prefer their supervisor not see, or the other folks in the ethics office not see. We want to make sure that they understand that needn't be reported. But it doesn't mean that we don't want to take a look at it. The only thing I'd probably counsel the employee about is about the potential concern under 18 U.S.C. Section 205. Make sure that he or she understands that they can't represent that organization before the government. Otherwise, a fairly simple analysis. All right, so we're nearing the home stretch here. And it does look like we're going to have some time for questions. So if you have questions, be thinking about those. Part 4, we talked about this a little bit already when we were looking at Part 1. Here we see that he has provided us some additional information about that entry for Yo-Yo Brands, his pension with Yo-Yo Brands. And it says the terms are $1,500 per month. This isn't a fantastic description of the terms of his pension. It suggests that it's probably a defined benefit plan, that at some time in the future, Yo-Yo is going to provide him $1,500 per month in retirement benefits. If we had more information on a previous report, I might just move that information over and let Peter know that. If this is the first time I'm seeing the entry, or if it's a new entrant, I'd inquire as to what the more complete terms. And the things we'd want to see is that he will receive $1,500 per month. We want to know when that would start, and we want assurances that that's sort of the extent of the arrangement. We have another question. Just a second, please. Marigold asks if we would still need to know Pete's position in the Knights of Columbus. And here we're working for a fictitious agency, so we don't have the complete supplemental regulation for prior approval for outside activities. Many agencies in their prior approval requirements have exceptions for religious, political, social, and fraternal organizations. I couldn't say that all agencies do, so we want to look at the requirements under that supplemental regulation to find out if we would need to have him file a formal request for prior approval and give him advice. The 450 does not require that information. The 450, and I can show you here on the instructions, says do not report any position with religious, social, fraternal, or political entities. So from the 450 review perspective, the Knights of Columbus doesn't have to appear on the report. That's a great question, so thank you for asking. Let's see. So again, with the terms of the pension, we'd want a little bit more information. We want to know, when the agreement or arrangement began. So the year he entered into this pension agreement, the year that he will begin receiving this benefit, and any additional stuff. We might ask, is that the extent of the agreement? But this does give us a good hint that what we're looking at is a defined benefit pension plan. And we'd analyze that the way we discussed in Part 1. And finally, we have a couple of gifts reported on Part 5. And this is another area where having really good ethics record keeping helps you tremendously. If I saw this reported, the first thing I would do is dig into Pete Moss's ethics file and see if we have any opinions for him where we looked at or analyzed these gifts. And if we did, I would be very relieved. And if we didn't, I might have some serious concerns. So here we have from Tiger's Eye Corporation, airfare and lodging to give a speech in an annual conference. It's possible that this was actually an official duty activity. If FBA had assigned him to do this, and maybe they accepted the airfare and lodging under 31 U.S.C. 1353, which is our travel payments from outside sources authority, we actually wouldn't need this to be disclosed because that's technically a gift to the agency. So this is an area where if you keep good ethics records, and when you provide Pete advice, you keep that advice in a place that you can easily reference it, you'd know that, hey, we saw this Tiger Eye Corp conference invitation, we did the 1353 analysis, and we authorized the agency to accept that gift. We could take the entry off with Pete's permission, and we wouldn't have to worry about it. If this is something we'd never seen before that Pete was maybe doing in his outside activity, his outside life, we'd want to do a complete gifts analysis. We'd want to find out if Tiger's Eye is a prohibited source, and it doesn't appear on our list, but that doesn't mean it isn't. We'd want to find out if they extended this gift because of Pete's official position, and if they did, we'd want to either make sure that an exception applied or take some action if this was a prohibited gift. But hopefully what this is what it looks like, where it was actually an official duty activity. He was invited, and Tiger's Eye offered to pay for his travel and lodging. Joseph Heller has a fantastic question. Thank you, Joseph, for this question. This is an excellent area for consideration. Joseph asks, if Pete starts receiving the benefit while working at FBA, would he be prohibited from working on matters involving Yo-Yo? So say he's currently receiving this benefit from Yo-Yo. He's getting a check for $1,500 per month pursuant to his pension agreement from Yo-Yo Brands. Would he be prohibited from participating in all matters that would affect the financial interests of Yo-Yo? And what we would have here is, again, a 208 ability or willingness situation. His interest is in the receipt of the check. So he would not be able to participate in particular matters that would have a direct and predictable effect on the ability or willingness of Yo-Yo Brands to pay his pension. That would be our analysis under 208. We also have to look at subpart E of the standards, or 5 CFR 2635-502, And there we'd find he has a business, contractual, or other relationship with Yo-Yo. So he would have a covered relationship, and he would not be, he should not participate in particular matters involving specific parties that involve Yo-Yo Brand. So where Yo-Yo is a party or represents a party, unless he's authorized. So that would be our analysis in the case that he was actually receiving the payment. I hope that helps, Joseph. But that's a great question. Thank you. And our final entry here is speedy.com, where we have he received a laser printer fax machine. This would be another question where we'd want to find out, why was this gift extended? Was it given because of his official position, or was it from a prohibited source? Is Speedy someone that does business with the FBA? Another question I'd ask is if this was actually a gift to the agency. Did he receive this in his capacity at FBA, and is the laser printer fax machine here at the office? In which case, if he accepted it on behalf of the agency, it was actually a gift to the agency and not to Pete Moss, and we'd have to determine whether or not our agency was permitted to accept that under our organic authorities or our agency gift acceptance authority. If he received this personally, again, we would do the same analysis. We'd find out, is Speedy a prohibited source? Were they extending this to him because of his official position? And then we want to look to see if an exception applied. If it did, we would hope to have an opinion that we'd already issued, or we could draft up some guidance immediately. If it's a prohibited gift, we need to take some steps to remedy that situation. We have another question. Would you also need to do an outside activity analysis, teaching, speaking, and writing for Tiger's Eye Corp since he gave a speech? You very well might, if this was an outside speech. If he was engaged in an outside speech, that might constitute an outside activity. Again, we'd want to look at the text of our supplemental agency regulations. Some agency regulations require prior approval for those things, others don't. If it were an official duty activity where FBA actually assigned him to go to this speech, it wouldn't actually be an outside activity or an outside position. So we probably would do a different analysis. We'd do our 31 U.S.C. 1353 analysis to determine if we could accept the airfare and lodging. And then we would just have to do the kind of management analysis, whether or not it's appropriate to send Pete to that to give that speech at the conference. But again, that's a very, very good question, and those are the right questions to be thinking about. All right, so that brings us to the end of our analysis for Pete Moss. And as you can see, we're going to have a lot of issues we want to discuss with Pete. I think where I would start with a form like this, where you're going to have some substantive remedy required. So it looks like we're going to have some divestitures, some recusals, and some requests for more information, is to take care of those substantive issues immediately. So I would provide Pete with the direction to recuse from matters affecting all the financial interests that we've identified and all the covered relationships we've identified immediately. I would communicate to him those areas where he's going to need to divest himself of certain holdings, and then begin drafting correspondence to effect that divestiture, or those agreements to divest within the specified time period. I would also, while making that communication, collect as much of the supplemental information that we identified as necessary from him at that time, and then begin working on a formal advice document, be that a formal piece of written advice or an agreement between Pete and the agency to take the necessary remedial steps to come into compliance with the laws and regulations, or to remain in compliance with the laws and regulations. But the very big issue is those immediate issues that we've identified. We want to make sure that Pete doesn't get into any trouble immediately, so we're going to want to contact him as soon as possible and make sure that we effect those recusals and clarify to him the immediate remedies that are required, and then take the time to do the thorough analysis and get all the correct information so we can give him the final advice product. So we do have a few minutes for questions, so I'd like to open it up. If anyone on the Hangout has questions, please continue to type those into the box. And let's open it up on the phone again as well, please.
Yes. If you would like to ask a question, please press star, then 1. Record your first and last name clearly to ask your question. To withdraw that question, please press star, then 2. Once again, to ask a question, please press star, then 1. Record your first and last name clearly. One moment. We have no questions on the phone line.
Great. Thanks very much, Kevin. And I'm not showing any questions on the Hangout either. I'd like to thank everyone for joining us today. I hope this exercise has been helpful. I also hope that you'll join us tomorrow for the debrief of the Nikolic report. That's the second report. And again, just like this report, if you'd like to take a few minutes and take a crack at it yourselves, I think you'll get a lot more out of the debrief tomorrow. If you don't have the time between now and then, that's okay. Please still join us. You will get something out of the review. If this was kind of the cartoon version of a 450 review, tomorrow's report looks a little more like a live fire exercise. So we'll get some different lessons learned, and it'll give you an opportunity to find out if you're actually retaining and are able to apply some of the information that we've provided over the past few days. Again, thank you very much. If you think of questions between now and then, we'll also have some time tomorrow to address your questions. We do hope you found this helpful, and we look forward to seeing you tomorrow. Thank you for joining us.
This concludes today's conference. All participants can disconnect at this time. Thank you.